Hi, everyone. Thank you for joining us today for Constangy's webinar, Crossing Digital Borders, Risk of Remote Work for Employees. A couple of housekeeping items before we get started. If you have questions throughout the presentation, please submit them through the chat function. You can access the chat through the toolbar located at the bottom of your screen. Our presenters will leave some time to answer your questions. If they are not able to address your questions during our scheduled time, they will follow up with you individually via email. This program is approved for Sherman HRCI credit. We will be sharing those codes at the end of the presentation, so please stick around in order to get the codes. Lastly, we will be providing a copy of the PowerPoint used during today's webinar and a recording of the presentation. These materials will be sent to you once the recording has been uploaded by tomorrow morning. I'm now going to turn it over to today's presenters.
Well, hello, good afternoon. Today we are going to be talking about the risks of a remote workforce from several different angles, including immigration, labor and employment law, and data privacy and security. And we'll also touch on some policies and best practices as well. So today we have Aaron Chang presenting from Winston-Salem. He is an employment law attorney. And myself, I am an immigration attorney located in Raleigh, North Carolina. Kelly McGrath is also an immigration attorney located in Atlanta and Raleigh. And Allison Prout is senior counsel in Rochester, and she specializes in data and security privacy law. Good advance. Thank you. So when the pandemic hit in 2020 and ensuing lockdowns occurred, we saw many changes in workforces, many employers allowing employees to either go to hybrid mode or pure remote mode, sometimes temporarily, sometimes permanently. And when the workforce includes individuals who are on sponsored work visas, there can be special considerations to take into account when allowing employees to relocate. In addition, many employers have discovered since the pandemic that they may have had employees that have chosen to self-relocate without informing their employer. And in other situations, we have seen managers perhaps unilaterally approve an employee's self-relocation request without consulting anyone else at the organization, which again can present compliance issues for the sponsored workforce.
Thanks for kicking us off, Justin. So from an immigration perspective, the H-1B visa is one of the most popular visas for our corporate clients. The H-1B visa is crucial for U.S. employers to fill specialized roles with skilled foreign workers in fields such as the information technology space, as well as engineers, researchers, financial analysts, economists, and many other specialty occupations. So given the popularity of this type of visa and the popularity of remote work, what sort of issues can employers run into when combining the two?
Well, Kelly, that's right. The H-1B visa is one of the most common visas in the United States for professional workers. So this is one that is important to focus on. When an employer files an H-1B for a worker in the United States, they are testing under penalty of perjury that they will comply with the terms and conditions of employment as set forth in that petition they file with the government. Some of the most important terms and conditions that apply to H-1B workers include the worksite location where the employee is working. The H-1B is location specific. Another important compliance condition is the prevailing wage requirement. Employers are required to pay the H-1B prevailing wage each and every pay period in which it's due and owing. If there's going to be a material change to the terms and conditions of an H-1B worker's job duties or their location or any other terms and conditions, the employer is required to proactively file an amendment to that H-1B before there's a change to the terms and conditions of employment.
So Justin, you touched on the H-1B being location specific and that there is a prevailing wage requirement. How does that work?
Yeah, Victoria, if you could advance to the next slide. Thank you. So yes, there is a prevailing wage requirement. That's one of the most important terms and conditions and compliance issues that applies to H-1B workers. So with the prevailing wage, just this way of background, that is typically determined by Department of Labor wage data, which is based on a few factors. For example, the type of occupation the worker is employed in, the relative seniority of the position. More senior positions that require more experience and education will have a higher wage level, and they also vary by market location. So, for example, if we were to take a software developer that is a more senior level software developer position that requires a significant amount of experience, the prevailing wage for a software developer, let's say in Atlanta, Georgia, is approximately $150,000. Whereas the same software developer position in San Francisco, the prevailing wage is approximately $206,000. So if an employee were to request to move from Atlanta, Georgia to San Francisco, in order to accommodate that request, the employer must be willing to meet that San Francisco prevailing wage of $206,000. So if the employee is already at or above that wage, then we would have no wage concern with that relocation. But if the employee is being paid more in line with the Atlanta prevailing wage of $150,000, we would have a $56,000 wage discrepancy. And most employers would not be willing to raise an employee's salary by $56,000 just to accommodate a personal relocation request.
Thanks, Justin. That gives us a great overview of why changes in work mode or locations should be vetted prior to any changes. What happens if the prevailing wage isn't met?
So the prevailing wage is not met, for example, because the employer didn't analyze this issue before approving a relocation request, or the employee decided to self-relocate without informing the employer, then the employer is now out of compliance and has a violation. And that creates potential back wage liability. The wage requirements of H-1B workers are enforced by the Department of Labor's Wage and Hour Division. The employee can pursue a back wage claim with Wage and Hour, and Wage and Hour can assess not only back wages, but potentially penalties and interest. And the Department of Labor could decide not to limit that investigation to the individual employee who brought a claim. They could launch a wider spread investigation of the H-1B workforce to determine if there's a wider spread issue with how the employer is paying their H-1B workforce. Sometimes if there is a relocation that's occurred with a wage discrepancy, the prevailing wage issue may be unresolvable. In other words, take our example of someone moving from Atlanta to San Francisco. If the employer is not able to increase the employee's wage by $56,000, then a few things may have to occur. The employee may have to be moved back to their original work site immediately. And the employer may need to consider whether they need to cut a check to the employee for the back wages that have accrued during the entire time they were not paid the required prevailing wage in the other work site. And if the employee is not willing to relocate back to the original work site, then the employer may have to consider terminating that employee.
Those are certainly some high stakes for meeting the prevailing wage. What are the risks if the employer fails to file an amended H-1B petition?
Right, so as I mentioned earlier, there is a proactive requirement on the employer to file an amendment to the H-1B if there is a material change to the terms and conditions of employment, such as a location change. If it comes to the government's attention that the terms and conditions of employment are not being complied with, then the government can move to revoke the H-1B based on the employer's fraud and misrepresentation. Now, typically in these situations, the employer doesn't intend any fraud or misrepresentation. But in the view of the government, if the employer is working the H-1B worker outside the terms and conditions set forth on the H-1B petition, they view that as misrepresentation or fraud. If the H-1B is revoked, that obviously can disrupt the employment authorization of the employee, their ability to continue to work with us. One of the ways this can come to the attention of the government is that DHS does have an administrative site visit program, and that includes the H-1B visa program. And in an administrative site visit, an immigration officer will come to the work site where the employee is supposed to be working, and they will interview both an employer representative and the H-1B worker themselves. And the primary purpose of that site visit is to ensure that the terms and conditions of employment as set forth in the H-1B petition are being complied with. And if they find that they're not in a material way, they may move to revoke that H-1B. If we discover, for example, that an employee has self-relocated without our knowledge and is working in an unauthorized location, and by unauthorized, I mean a location not listed in an H-1B petition filed with the government, if we discover that, we have to immediately stop that employee from working in that unauthorized location because they're not authorized to work there. But we can't stop paying them, because it's also illegal to bench an H-1B worker. You cannot take an H-1B worker out of productive status and not pay them. So we have to continue to pay them and immediately move them back to the location that they're authorized to work in. Now, not all worksite location changes are problematic. So, for example, moving worksites within commuting distance of the original worksite is typically fine. Okay, that's okay, but there can be postings that can be required in connection with that. There are also special short-term placement provisions for H-1B workers that can allow them for a very short period of time to work in a location other than the one listed in the H-1B petition, but there are obligations and responsibilities that attach, and those are for very short periods of time. If you're considering using the H-1B short-term placement provisions, you should speak with counsel to ensure you understand the obligations that attach to that.
Thank you, Justin. Given that the H-1B visa is a non-immigrant visa and is limited to a 6-year period of stay, many employers elect to start the green card process for their employees to allow them to live and work in the US beyond that 6-year max stay. Do we see complications arising from remote work or work relocation during the green card process?
Yes, absolutely, Kelly. That's a very critical point. So many employees on sponsored work visas go through a green card process that's a multi-step process called the PERM process. H-1B workers typically go through this type of green card process. The PERM process involves a labor market test, and it's a labor market test to determine whether there are minimally qualified and willing U.S. workers available for the position we wish to sponsor our employee in. That labor market test is for a specific labor market, right? where the worksite location is for that employee. So if the employee changes locations, that can invalidate the labor market test process that we are conducting. So some of the key considerations to think about when considering a relocation for someone who is in the green card process is, will the process have to be restarted as a result of the relocation? If it does, do we have sufficient time? As you mentioned, most visas are time limited. The H-1B visa is limited to 6 years. If we have to restart the process, will there be sufficient time? If there is not sufficient time, then our employee may run out of their H-1B status or other work visa and have to leave the United States. Then their employment may come to an end and they may have to depart the United States. The perm process can take a long time to get through. It's not a quick process. And the other things to keep in mind when changing locations is that the labor market test may vary by location. So going back to our Atlanta and San Francisco example, conducting a labor market test for a software developer in Atlanta may yield a different result than conducting that labor market test in San Francisco. Similar to the H-1B, there's also a prevailing wage requirement that attaches to the green card process. So we also have to ensure that we'd be able to pay at least the prevailing wage in that new labor market. And Victoria, if you could advance to the next slide. Thank you. Now, not all relocations are necessarily problematic. Similar to the H-1B, movement within commuting distance of the original work site typically is not an issue. There is also a way to set up the perm process to conduct the labor market test for a remote worker. This is not a hybrid worker, but for positions that truly allow the duties to be performed from any location in the United States. For a remote position, that can be set up in a way that allows the employee to relocate without having to restart the process. And there are other types of green card processes that may not be location specific, so that a location change may not have an impact.
Thanks, Justin. Many of our attendees are likely aware of the new remote I-9 process, the verification process that rolled out last year. Do you have any guidance about the new process for remote workers, and is the process different for sponsored employees?
Yeah, so first of all, the process is no different for sponsored employees. It's the same whether the employee is sponsored or they're non-sponsored. I-9 verification is an entire topic unto itself, and one we don't really have time to delve in too deep today. But this is a very helpful rule. For employers have been asking for some type of virtual or remote I-9 verification process for many years. And apparently it took a global pandemic for the government to realize that maybe that might make sense. So this is a very welcome rule, but it does have responsibilities, obligations that attach, and some risks that also attach to this process that are important to be aware of. We did do a webinar entirely devoted to this topic last year, and we have a link to that webinar on this slide here. So if that's of interest to you, I would recommend to you watch that webinar.
Thank you, Justin. At the end of this segment, I think it's important to highlight the need for employers to have policies and processes for reviewing remote work or relocation requests prior to any changes, specifically for sponsored employees. We find that the clients who are the most successful in adhering to these policies set clear expectations for employees, managers, and recruiters. They also set up policies for adverse employment action for policy violations that create potential risk and liability for the organization. We have even seen employers fire sponsored employees for not adhering to these policies and take adverse employment action against management that allowed employees to break the rules. And with that, we will turn it over to our next topic.
Thanks, Justin and Kelly. My name is Aaron Chang. I am an attorney in our Winston-Salem office. I specialize in just regular labor employment, but I do spend some time on the labor side. So today I just want to go over some of the L&E implications of remote work. I'm sure a lot of those who are on this webinar have had some questions or had some issues relating to remote work in the labor and employment area. And so just want to cover a couple of big things. So I will be the first to welcome you to the new normal. Remote work is more than likely here to stay. People have come to realize, and COVID is to thank, that work can be done away from the a centralized site, and it can be done in a manner that's just as, or if not more efficient. So employers and employees found out that in some industries and for certain workers, remote work just works well for them. And so COVID also gave employers and employees the ability to test out different work arrangements. So you have your telecommute, you have teleworking and hybrid, where you sometimes come into the office or you're just doing work from home. Also, there is part-time and full-time remote positions. And COVID gave employers and employees the ability to test these things out. And what we found there are some clear advantages. Flexibility being the biggest one, biggest advantage. Employees are able to work from home and get their work done, and not have to commute, not have to waste time in commute. Obviously, COVID was the safety issue, health and safety issue. So that was the biggest, or one of the biggest. Productivity, if there are adequate guidelines in place, some employers actually saw an increase in worker productivity when switching to a remote work arrangement. And there was also a cost advantage. Some people closed offices, some people moved away from brick and mortar, and everybody is working from home. And so you save on real estate costs, supply costs, administrative costs. So those are some of the advantages that employers and employees found. On the flip side, there's always disadvantages. With flexibility, with some employees, you give them too much flexibility, they're going to take advantage of it. And so that's where employers setting good guidelines, good policies in place can somewhat counteract that. With productivity, again, some employees will take advantage of these kind of arrangements, and you will see their productivity dip. And then from the cost standpoint, you may save on the real estate and other kind of costs like that, but there is a cost for complying. You may have to supply employees with technology and stuff that they need to get the job done that they aren't going to have at their house. So there are clear advantages and disadvantages. So here are some key elements that we have seen for telework to be a success for employers. Top management needs to buy in, and obviously they need to approve of it. But not just top management, everyone needs to buy in. You can't have someone with a plan, and thinking it's a good idea, where other managers are like, no, I don't like it, and they fight it. You need to have a good buy-in from, top down, and there needs to be structure in it, which is having a good formal program in place, a good policy in place, and we suggest having a standard work agreement for certain employees. You need to educate your workforce. They need to know what the parameters are for remote work, whether it's hybrid, whether There are expectations of them, of their, how are they being compared to their peers, that kind of stuff. So you need to have a good policy and program in place, and your employees that are going to be working remotely, need to know what that is. So you train them on the above. You give out these policies, make sure they read them, understand them, and then have them ask questions. And finally, you need to have the right tools and technology. Obviously, employees need to have the right technology at home to be able to do the remote work that they might not have at their house, but that would have been in the workplace. So having the right tools and technology is definitely another key element to having success. So one of the major things that we have seen is that with remote work, or employers that are getting rid of brick and mortar offices, that doesn't mean you don't have to comply with FMLA, FLSA, Department of Labor postings, state postings. So employers must comply with these requirements for both on-site and remote workers. Like I said, there's FLSA, FMLA, OSHA, notices, and then state notices, and localities sometimes have their own notices. So an employer needs to know what the requirements of in the states where their employees are working. And this kind of goes to employers that have employees that are spread out all over the country. And you may have one worker in one state, but you need to check that state requirement to see whether, even if there's only one employee, whether there has to be postings and, is electronic enough. Many notice posting requirements can be satisfied with electronic postings. The Department of Labor has said that that is acceptable, as long as they're easily acceptable and employees know where to find them. So if you're going to do e-postings, make sure that you tell your employees where they can find it and how they can access it. Something in an email is probably okay, maybe something in a handbook or a separate standalone policy might be okay. You don't want employees to have to jump through hoops to find them, right? You want them to be relatively easily accessible. Explain how that they can access these postings, and if they have questions, speak to HR or whoever will be controlling these. And you need to, and the most important part is you need to check applicable state and local requirements regarding postings. If you have California employees in California, your postings may look totally different for employees in another state. So make sure and I do emphasize local as well, because some cities have their own requirements. So for confidentiality, this is a topic that many employers might not even think about, but they need to know that, or they need to make their employees aware that normal policies governing these issues continue to apply even in a work from home situation. So make sure that your employees know that confidentiality is just as important working from home, if not even more so, because people may not think about it. If you have a confidentiality policy, remind your employees of their duties under that. For example, if employees handle confidential or very sensitive documents, make sure, and physical documents, make sure that they either shred them or they have a way to get rid of them, and not just kind of throw them away in the trash without really thinking about it. From an electronic standpoint, make sure that they have like screensavers, or that their laptop locks when they're not using it. You can also think about using VPNs or other secure networks so that company data is safer. Other unique confidentiality concerns are, from a work at home situation is unauthorized access to physical records that you keep at home, or unauthorized access to electronic records kept on unsecured devices at home, and inadvertent screen sharing. When we do a lot of these remote conferences, sometimes you inadvertently share things on your screen. It's happened to me before. So just train your employees on best practices, and make sure your employees have the tools that they need to be able to maintain confidentiality. So some of the big things to be aware of are wage and hour issues in regards to the remote work. Beware of off-the-clock work and automatic time deductions. And this is very significant because in a work-from-home situation, there's not someone there to know when a person's working, and whether an employee is taking the appropriate amount of breaks and how long their breaks are. So you need to train managers and supervisors and your employees really that they need to document their work time, and that if they work outside of their working time, they still need to document it, so that there's no issues with unpaid wages. But you also should have a policy stating that employees are not to be working off the clock. That way you can reprimand them and discipline them if they do continue to do those kind of things. Conduct periodic audits of work time and see if it kind of matches up with what you would have expect of the employee based on their output. And be wary that for periods of inactivity, breaks of 20 minutes or less, that is compensable. And depending on the company's normal policy, whether meal periods, usually about 30 minutes or longer, whether they are compensable or not. And then think about possibly business expenses. If an employee needs to buy supplies for work, is it compensable to them or not? Those are some of the major issues. It's the off the clock kind of working, because it's easy to, you stop working for the day and you're at home already anyway, and then you think of something you need to do and you go do that. That's technically off the clock work, and it's compensable as long as they're doing work on behalf of the employer. So having a good policy in place and having good employee, letting employees know about it is a good policy to have. So with employee monitoring, employers just need to be aware that there are exceptions to the Electronic Communications Privacy Act, which prohibits unauthorized access or transmission. So there's the business extension exception if made on business equipment, but employers need to know that once it becomes personal, that they need to stop, which is sometimes hard to tell. There's a service provider exception. It's usually reserved for the telephone and internet companies, and then the consent exception. So sometimes employers will have employees consent that they would be monitored while working from home. So you just need to check applicable state and local requirements regarding that. So one issue that employers may not be aware of, especially those that don't deal with the National Labor Relations Board that often, is that the current general counsel, Jennifer Abruzzo, back in October of 2022, issued a memorandum suggesting that employer surveillance violates the National Labor Relations Act. So employers that use these monitoring systems like a keystroke logger or having access to webcams and those kinds of things, it is her position that based on that, that an employer violates Section 7 of the National Labor Relations Act because it discourages employees from engaging in protected concerted activity. So she wrote this memo. She has suggested this framework, a new framework for balancing employer interest and employee rights. However, the board has not implemented it yet, and we haven't seen much about it since. But just know that Jennifer Abruzzo has a very employee-friendly agenda, and she has pushed through a lot of things. And so it's just something to maybe keep an eye out on. So one thing employers might not think about, but is something they should, is safety considerations. OSHA requires, under its general duty clause, that an employer provide a workplace free from recognized hazards that are causing or are likely to cause death or serious physical harm. So you need to, as for employers, employees working from home, it's not too much that you need to do. You just need to know that that you tell your employees that they have to have a separate workspace that is only for, you know, an area for them to do work, and that it's free, you know, there aren't any hazards there. And also, if they somehow have a recordable injury while working, that they do let the employer know about it, but the injury has to occur while the employee was being paid to work, and the injury has to directly relate to the employee's work duties. So that could be kind of iffy there, whether, you know, if someone trips on a cable and hurts themselves, it's a good bet that it's probably an injury that needs to be reported. But again, it's just something that employees should keep a mind on. So equal employment opportunity issues, remote work as a reasonable accommodation. This is a big issue that has come up since the COVID, where employers want to work from home, and they will try to seek a doctor's note that says that they suffer from a disability and that accommodation that they are requesting is to be able to work from home. So again, you would just go through your normal reasonable accommodation process, and make sure that you're doing those things that you would normally do. You also need to be aware of discrimination issues in how you grant or deny remote work requests. Just make sure that you're not, whatever criteria you have, it doesn't doesn't have a disparate impact on a certain protected group. And then harassment. So this is something that is not really that big an issue, but sometimes with work from home, you have these meetings, and if people are telling inappropriate jokes during the meetings and those kinds of issues, that could rise to the level of harassment. So again, something that you just need to keep an eye out on, and I'm sure most employers would do that anyway. So for FMLA issues, I'm sure a lot of employers know about the 50-75 rule, which is FMLA applies for employers that have 50 employees within a 75-mile radius. So what happens when somebody's working from home? You know, how do you determine coverage? Is the house the place that you look for the 75-mile radius? And that is not the case. You look at the location where the employee has been assigned to determine coverage. You know, where's their supervisor located? You know, is that employee budgeted or assigned to a specific location? That would be the case. You may run into issues on completely remote work environments. That is probably a question for another presentation. So here are just some best practices for remote work arrangements. You know, determine which positions and which employees are eligible. Identify what criteria you're going to use. Evaluate states outside the organization's home state for which employees will be accepted, and prepare policies and procedures that address the issues that we've discussed. So for just a simple remote work policy, you know, make sure that this remote work is at the employer's discretion, and it can be revoked at any time based on business needs. The employee can still be required to report to office for meetings or certain occasions. That the employee has a dedicated work area free from distractions. Sometimes you might want to have that the employer can monitor employees and their work product, work, how they're working. So these are some of the major things we would recommend is in a remote work policy. And with that, I will kick it to Allie.
Awesome. Thanks, Aaron. So hi, everyone. My name is Allie. I am a data privacy and security attorney on Constangy's cyber compliance team. And I'm here to talk about how the employment law arena that Aaron, Justin, and Kelly were walking through kind of marries with the cybersecurity and data privacy law side of things. And really, what we're looking at is, what type of employee data do I have? And do I have obligations to keep it secure, to keep it private? And where are my employees located? Because that can also trigger certain obligations. And so on the next slide, we talk about kind of the intersection between, obviously with employment law and cybersecurity privacy law. But then when we're diving into that, what's the difference between security and privacy? And this is an important concept to understand, especially when it comes to remote work. And we have kind of new challenges around how we're protecting data, how our employees are protecting our company's data. So data security is all about, as I mentioned, protecting the data. So if we're dealing with employee information, we want to keep it safe from unauthorized access or acquisition. I'm sure we all both love and hate multi-factor authentication. We have to get a text to our phone to sign into things. That's a security measure to keep your data protected, to keep your company's data protected. On the other side of things, we have privacy. So data privacy is around kind of limiting what we're collecting, what we're processing, what we're maintaining, and giving our employees, depending on where they live, certain rights to that data. And the types of employee data we'd be looking at are typically in the buckets of personal information. So names, email addresses, beneficiaries, anything related oftentimes to their benefits. We're also looking at social security numbers on our tax forms, things along those lines, and just keeping that information confidential. That lies on the data privacy slide. So in terms of the legal landscape that's going to inform us and how we are protecting employee data, asking our employees to protect data, and handling the data. Right now, we don't have a federal privacy law that we have to comply with, which is very different for any of us that work in the international space. Obviously, the EU and the UK and Canada, we have a lot of federal privacy laws, but not in the US. Instead, we have industry-specific laws. So we have HIPAA when we're dealing with protected health information. We have the Gramm-Leach-Bliley Act when we're dealing with non-public financial information. HIPAA information would only really be relevant here, PHI, if you have a self-funded health plan. So that's where we might be in that HIPAA arena. We might have obligations to protect the data. And then from a state-to-state perspective, all 50 states have what's called a data breach notification law. So that's if specific types of information get out. Usually it's something along the lines of a first name, last name in combination with unencrypted social security number, driver's license info. If that type of information is breached, you may have obligations to report it. On the other hand, we have data privacy laws. And so those data privacy laws, the big one to contend with in the US space is really the CCPA, which we're going to talk about shortly. But that's where we're going to be having specific regulations around our employee data. So as I mentioned, the privacy protections that we provide to our employees does vary based on, I mentioned those kind of 50 states. It varies by location and it varies by the type of business that we're looking at. So typically, as I mentioned, we're dealing with that personal information piece. There's also privacy protections around health and genetic information. So if you use a retina scan to log into things or a fingerprint scan, there's privacy protections around that because it's called biometric information. There's also obligations around privacy when it comes to workplace surveillance. I know Aaron talked a lot about monitoring, and we're going to briefly touch on that as well from a privacy perspective, in addition to that employment perspective. So really, we're looking at what types of things do I need to put in place to comply with obligations to keep my employees' data confidential, private, what obligations, what rights do I need to give to these employees? So this is a general overview, and then we're going to shrink it down a little bit to California. So the California Consumer Privacy Act, we've probably all heard of it. It is a law that protects not only consumer information, but unlike the myriad other more than 15 states that have passed privacy laws, California also protects employee data. And so when they use the word consumer, just pretend that says employee, because it's the same idea. So the CCPA is going to apply in addition to any other employment laws we're dealing with when we're processing data. From a privacy perspective, the CCPA applies to personal information, which is really just anything that relates to an individual and can identify them. So first name, Gmail, email account, something as simple as an IP address could be considered personal information. Now, it doesn't apply to anyone under the sun. It applies to businesses that do business in California and meet one or more of the thresholds you see on the screen. So annual gross revenues in excess of 25 million. And that's not just your annual revenue in California, that's just generally. If you're annually buying, receiving, selling, or sharing personal information of more than 100,000 people, or if you're deriving 50% or more of your annual revenues from selling that personal information. So if any of those things apply, you're covered under the CCPA if you're doing business in California, and you have obligations around your employee data, which we'll talk about on the next screen, or next slide, excuse me. So under the CCPA, which was modified by the California Privacy Rights Act, basically some regulations, so you'll see CCPA or CPRA, you do have obligations to protect your employees' data. You also have to provide a number of disclosures. So you have to have an employee privacy notice. So basically when someone starts perhaps as your onboarding process and annually thereafter, you're going to give them a privacy notice that says, here's the data that I'm collecting, here's how I'm using it, here's how I'm disclosing it, here's your rights to ask me certain different things about the data. And it's not listed on this particular slide, but data subject rights exist for employees to be able to access the information you hold about them, with some exemptions, to delete information. Again, exemptions related to legal necessity, things along those lines. But there's a number of rights that they have that they can activate. Additionally, under the CCPA, we need to safeguard data. I call it ATPs. It's your administrative, technical, and physical safeguards. So that multi-factor authentication is something, encryption is something that can be used. There's a lot of different tools we have in our toolkit to protect the data reasonably. Data minimization refers to if I no longer need the data, I'm not going to keep it, or I'm not going to ask for more data than I need. One way to really help with minimization is retention and deletion policies. And this is the case even if you're not operating in California. It's a really great way to not have more data than you need, so that if you do experience a cybersecurity event, perhaps less of it is exposed. Additionally, under the CCPA, data mapping is extremely helpful. Data mapping just means understanding what data do I have? What am I doing with it? Where does it live? What if someone asks me to delete it? Will I know where to go? Vendor contracting and oversight, there's express requirements. You have to flow down very specific contractual obligations to your vendors that are handling personal information covered under the CCPA. So anyone handling employee information, think ADP, Bamboo, your timekeeping software, anything along those lines, you're going to need to have contracts in place with those entities that requires them to protect the data in the same way. And then finally, data protection assessments. This is essentially where you're going to say, all right, what am I collecting and doing with the data? And what are the risks associated with that? And how can I combat those risks? And you put it in a document to help inform you going forward. So those are our CCPA requirements. Now, employee monitoring, I know that Aaron touched on this a little bit from an employment law perspective, but it also exists from a privacy perspective in terms, I say privacy as in privacy law specifically. And it's especially pertinent when we have remote workforce, because different states, not all states, but some states have requirements around when you're monitoring employees. And monitoring it's broad, right? It could be, I have a camera in the break room. It could be, I'm able to access someone's emails and make sure they're not doing nefarious things. I'm able to see who's logging in where to my systems. So when I'm doing that in different states as a business, I may need to provide a notice that I'm monitoring. And this can go, we're thinking practically, how do I give this notice to individuals? Oftentimes it can appear in an employee handbook. It can appear in an acceptable use policy. It could be an onboarding document. And it really is just going to need to say, there's no right to privacy with respect to the computers that you're using in our systems. We may monitor them and you acknowledge that you understand that. So a notice would be required. The employee in many states has to acknowledge it, for example, with a written signature, although you could also do it, load it into DocuSign. There's also restrictions on where you can monitor. I think we can all agree there's certain areas of the workplace we shouldn't monitor. We shouldn't be accessing cameras on individuals' computers without their authority if they're working remotely when we're dealing with that hybrid workspace. So obviously this is relevant from a remote perspective, because if I have individuals in, let's say, Delaware has requirements, Connecticut has requirements, New York has a pretty stringent requirement. So I want to understand where my workforce is to know, okay, if I have an individual in one of these states, I need to make sure I'm providing this notice. Or maybe I make the practical business decision that everyone gets the notice, so that then I don't have to deal with an ad hoc decision-making process. So again, it varies by state, but something that's crucial to put into your notices to employees. Now, we've talked a lot about protecting the data, privacy requirements, especially from a remote perspective. From a cybersecurity threat perspective, there are a lot of threats out there, as you can see on here. I know we're all living in a world of, it's not necessarily if we're going to get breached or have an incident, it's more of when will this happen to us? And that's why it's important to recognize appropriate security controls from a remote perspective. When we don't have all of our people under one roof, we want to make sure that we are advocating for them to keep everything secure, including employee data and company data. And that's because of all of these threats here. Ransomware encryption, they lock your data down and you have to pay a ransom to get it back, or to just have them deleted if you have backups you can restore. Business email compromise, this is a huge one. If we only have single-factor authentication, it's easier for people to get in. People can click on phishing links, things along those lines. We also probably have gotten passwords before from our CEO asking us to buy him perhaps a gift card, something along those lines, right? So checking for those. There's also vendor risk, right? What if ADP gets breached? What if Bamboo gets breached? What if one of our tools that we use has an incident? There's risk there. And then insider threats. This is a little more pronounced from a remote perspective, because again, we don't necessarily have the visual on our employees. We can't see kind of if there's compromise happening apart from monitoring their system. So these are all the threats that exist, and they're the reason why we want to have this kind of data privacy and security regime and culture from a remote perspective to help us to avoid the incidents, or when we have the incident, potentially avoid more fallout than necessary. So in terms of building that data security and privacy program for remote work, we all want to be building a data security and privacy program that is sustainable, right? It can adapt over time. It's scalable. It's something that works for our company. There's no one size fits all approach. It really depends on how much monetary resources you have, how excited are people about it or not excited, what is the risk? Obviously with employee data, that's highly sensitive data, typically. So the risk is high for most of us on the call. And we want these programs to address our people, our policies and procedures that we have in place or may want to put in place, and the types of technology that we're using. Because we don't just want security to be only in the hands of IT staff and tech consultants. We want to build a culture around data security and privacy that is even more effective. The stronger it is, the more it will permeate through the remote workforce. Next slide, please. So from a security safeguard perspective, what are things we can do when we're dealing with a remote workforce to protect our data? Well, some of these are pretty self-explanatory. Requiring complex passwords, multi-factor authentication, Virtual private networks are really handy for remote work because your employees can simply log in to the VPN, and that provides a more secure workspace where a lot more of your things are locked down. So it's a great tool that you can use. Geofencing simply, it kind of means what it says. You're going to fence in who can access your systems. If you don't have employees in Canada, maybe we don't accept IP addresses from Canada. If we know that we have remote work employees, across the US, then we're just going to accept IP addresses from there. Firewalls, another great tool. Most of us should already be using these, but again, helpful from a remote perspective, just as another edge that we can have. And then access controls. So when we're dealing with a bunch of different individuals all over, we don't necessarily want them to be able to access all parts of our systems, all of our data. We don't want our HR personnel necessarily accessing, everything under the sun if their job is limited to one thing. So having access controls helps us to limit who can see what data and kind of where we might have compromise. At the organizational level, having acceptable use policies. This is how you can use our systems. This is how you're allowed to use email. This is how you're allowed to use the phones. Everything along those lines. Bring your own device policy. If we're dealing with remote work, a lot of people are using their own devices. So having specific policies that individuals have to acknowledge and read. Again, assessing those ATPs I talked about. What are the security safeguards that we have in place and that we're employing across our remote workforce? What is the third-party infrastructure we're using? ADP, Bamboo, all of those. I've mentioned them many times, but kind of understanding what kind of data they're getting can help us understand the risk. Regular auditing and testing. And then finally, training the organization to create this culture of security, this culture of privacy. And on the next slide, when we're doing this, it's really cross-departmental. As I mentioned before, we don't just want this to live in the hands of IT. We really want to have data security and privacy champions across the organization. And then they can kind of funnel everything down. Because I think a lot of us agree that employees are often more apt to follow things or be excited about things if their superiors are. So kind of developing awareness, having champions across the organization, coming up with creative solutions. Perhaps your employees are more interested in watching video trainings or things along those lines. So understanding your audience and training them and getting that stakeholder buy-in across the organization really can be helpful. Especially when you're trying to make remote employees excited and they're not a bunch of bodies in the office. And then finally, just reviewing our employee data protection practices annually is a great way to help mitigate risk, promote compliance, understanding where our employees are located. As we talked about, am I in scope of the CCPA? Do I have California employees? Maybe I don't have California employees, but I have to provide certain privacy notices, or I have sensitive data based on where they live. Understanding the data that I'm collecting from employees is extremely important. That way I know what to protect and where. Managing my monitoring, having those privacy notices that say I'm monitoring you, promoting security and privacy awareness, and then having those acceptable use guidelines for using our systems. And then just as final thoughts, we have a number of policies here. The first set is related to a lot of employment-specific policies. I know we have a few minutes left, Aaron, if you just want to run through those.
Yeah, so kind of echoing what I said earlier, you want to have a good posting and the instructions on how to get them. You want to have a clear timekeeping policy, especially for those non-exempt employees. You want to have a good workplace safety policy. And if you already have one, you can just kind of use that and morph it into your remote work policy. Definitely have a harassment policy. I'm sure most employers, I'm sure you all have a harassment policy, but make sure that you note that that policy does apply to remote work. Confidentiality and document security policy, definitely want to have a mention in your remote work policy. And then obviously the actual work from home policy will be a kind of a separate standalone, but will include at least mentions to these other ones. So.
Yeah, and from a cyber policy perspective, and this is all available to everyone after the fact when you download it, so you can kind of see this list in real time. But just having policies around managing your data, training, relevant notices, acceptable use policies, and then just a written information security program. That's just a quick plug for that. And I think that covers us from a policies perspective. Victoria, I'll let you take it away.
Yes, we have a couple of questions in the chat. As we mentioned, if you're not able to stay on and go through, we can also reach out to you individually and answer those questions via email.
So there are a couple of questions that came up in the chat. Some of them are really quick to answer, so I'll just take a quick second for those that are going to stay on. One question was off the clock issues pertains to only to non-exempt employees, right? Or correct? And that is correct. Obviously, non-exempt employees are the ones you want to be tracking. But this is also a plug to say that employers should make sure that their exempt employees are actually exempt employees, and to not forget that the threshold just went up on July 1st. So make sure that your exempt employees meet those thresholds. And the other question, actually there's two more, but one other question kind of deals with the FMLA and the 5075 rule. I should have mentioned that the Department of Labor issued a Field Assistant Bulletin 2023-1. So about February of last year, the Department of Labor issued a Field Assistance Bulletin that deals with remote work and DOL issues like the FLSA and FMLA. Under that guidance, so the question is for FMLA eligibility, when we look at how many employees are within the 75-mile radius, does that also count other remote employees who are assigned to that location? Example, if there's only 10 employees who work from the office, but 60 who are fully remote but assigned to that office, does FMLA apply to all of those employees? And the short answer is yes, because the Department of Labor considers the employee's work site, where they are assigned, where they're receiving, where they're receiving their assignments from. And so the count of the 75 or the employees within the 75-mile work site includes all employees whose work site is within that area. And they say specifically, including employees who telework and report to or receive assignments from that work site. So yes, it's kind of convoluted, because if you have 60 employees working all over America or all over the United States, and only 10 people working in the office, but they're all assigned to that office, then under the Department of Labor's interpretation of the FMLA, they would all be eligible for FMLA as long as they meet the hours requirements and all the other requirements. And then there's one more question I see. It says we have all the policies, but no remote work agreement. Should we have an agreement that is signed by all who work from home? I would suggest having one. We've definitely done them for clients. But yeah, it is that way. You have something that shows that they saw what the policies were, that they were told what they were, and they knew what they were when they signed up for it. Obviously, we always, as lawyers say, the more paperwork, the better when it comes to those kinds of things. So it's not a bad idea to have, right? But you just want to make sure that it is an appropriate policy that they do sign. So I've taken up everyone's time. So
that's all right, Aaron. Thank you all for joining us today. It looks like we don't have any more questions coming in. So with that, we will now end the webinar. Thank you all again for joining us.